So Mikey asks, what's the case for Chad is acting in self-defense once Kyle fired a warning shot, a deadly show of force?
Yeah, I mean, you can make that argument, right? He believed he was going to be shot, so he's trying to defend himself against the gun. But so what? I mean, that's not actually what happened, right? He didn't actually defend himself from that situation. And you don't get to shoot someone because they shoved you off your porch. I mean, I see a lot of this stuff where, well, basically they're justifying the shooting because of the custody issue, or he got pushed off his porch, or Chad jumped up on the porch, or none of those are legal justifications for shooting somebody dead. The legal justification has to be that they present as an imminent deadly force threat in the moment that you shoot them. This other stuff is just noise. It may inform that decision, but it really only matters if you believe the shooting itself was, in essence, lawful, and you're looking for ways to attack that otherwise lawful use of force. And I don't see the use of force here being lawful because of the positions of the people, the distance involved, the lack of Chad Reed having any kind of means to project force at Kyle over that distance in the moment the shots were fired.
Right.
Now, people may believe, hey, I should be privileged to shoot someone if they shove me off my porch. That's fine. You can have that feeling if you want. You can even propose that legislation, maybe get that passed into law, and maybe that would then be Texas law. But that's not what the law says you can do now.
Yeah, that's a very good distinction to make for a lot of people, is that there is a difference from, the first hour that we were talking about. I was sort of talking about this when both of you left, that the first hour we were talking about what some proposed changes to the law, like what the law should be or what the law could be. But typically what we're talking about in this channel is what the law is. And so that's sort of representative of sort of the going after an hour in on this particular live stream. That's really what we're talking about then, is we've sort of shifted the mindset going from what the law should be to what the law is. So, Jesse,
there's also a major area of misunderstanding here. I see a lot of big capital letters in the comments here. People saying that is what the law in Texas says. No, folks, that's not what it says. You're misreading the law. There's law in Texas about defense of. If you like, it's okay with me.
It's right here.
Texas has a law that creates a legal presumption that you had a reasonable fear of imminent deadly force harm if you're dealing with a forcible, unlawful intruder into highly defensible property. In this context, meaning your dwelling, and the front porch would count as part of that property for purposes of this legal presumption. But folks, it's a legal presumption. It's not an absolute 007 license to kill. It's presumed that you're facing that threat, but that presumption can be rebutted by other evidence. And the evidence here is that the person who was shot was unarmed, standing still on a porch 10 feet away, not presenting in the moment an imminent threat of deadly force harm. That rebuts that presumption. You're not automatically privileged to shoot that guy.
So explaining what what it says here, this is what people are referring to, where it says you can use force if A or B, right? But A1 or the statutory requirement for A2 needs to be met for these to be met, right? That means A2 is referring to imminent deadly force being perceived. So if you don't justifiably perceive imminent deadly force, then this part doesn't matter. It doesn't matter if you're thrown off your porch. It doesn't matter
by the way,
if somebody does something.
I really consider these legal presumption of reasonableness. I think they're good laws. I'm a fan of them. I would advocate for them, but they don't really matter. I mean, if you've shot someone and you're claiming self-defense, it's already legally presumed that you had a reasonable fear of imminent deadly force harm, because the state has to disprove your claim of self-defense beyond a reasonable doubt. You're presumed innocent. You're presumed to have a valid defense until the state disproves it beyond a reasonable doubt. And that's true on the street, on your porch, in your house. All that this legal presumption language does is kind of formalize it in the context of your home.
Right. And really all that's referring to is the burden of proof. So typically in any kind of a criminal case, the prosecution bears the burden of proof for most of these things. I mean, when it comes to self-defense, that's typically an affirmative defense that gets brought on by the defense. So that means an affirmative defense usually means that the defendant then has a burden to show that part, to show that they were actually acting in self-defense. So a statute provision like this one is what we would call a burden shifting provision. So that would basically mean that it shifts the burden back over to the prosecution to show that essentially they didn't have or that the defendant wasn't acting in self-defense.
Right. I mean, the only burden on the defense is what we would call the burden of production, which is to provide some prima facie evidence in support of self-defense, which really only means more than zero evidence. So if you show a hair of evidence that's consistent with self-defense, you've raised the legal defense of self-defense. Now the state has the burden of disproving it beyond a reasonable doubt. When we say it's legally presumed that you acted in self-defense, well, you already have that presumption because the state has to disprove it beyond a reasonable doubt already. So it doesn't really do much, except that it's useful as a jury instruction to read to the jury to kind of reinforce where these burdens are. And that's always a good thing to do.